Our second case scheduled for oral argument this morning is Jared Cleckley versus State of Florida. Mr. Ufferman, are you ready to proceed?
Yes, Your Honor.
You may approach.
Thank you.
Again, Mr. Ufferman, we reserve 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, please. 5 minutes, Your Honor.
So noted. Madam Clerk, you may continue, Mr. Ufferman.
Thank you. Good morning. May it please the Court. Michael Ufferman on behalf of the appellant Jared Cleckley. I'm hoping to focus my time this morning on the first two issues raised in the briefs. The first issue concerns whether it was error for the trial court to consider a greater charge than the one for which my client entered a plea to. The second issue concerns whether or not it was error for the trial court to consider unsworn victim impact statements. Let me start with the first issue, and before I do, let me give a little bit of background facts regarding this case. This case occurred, it was a tragic incident. As a result of the incident, Gary Diamond died. He was shot by my client 5 times. The incident occurred shortly after Christmas in 2020. My client ran into his former girlfriend, the mother of his children, at a bar. My client became upset. He later left her some threatening voice messages, threatening to come to her house and kill her family. He was either upset because she had a new boyfriend or she was at the bar and wasn't home with the kids. We know after midnight, about 15 or 20 minutes after he left those voice messages, he showed up at he showed up at the former girlfriend's house. Her name is Caitlin. Caitlin came out from the house. My client was in his car, parked in the driveway of the house, and an argument ensued. Caitlin's mother, Mrs. Diamond, came outside, and ultimately Mr. Diamond came outside. Mr. Diamond engaged in an argument with my client. My client was in the car. Mr. Diamond was reaching in. At some point, my client put the car in reverse, and the evidence shows that Mr. Diamond was in the vehicle, leaning in as it was going backwards in reverse. The vehicle then hit Mrs. Diamond. Obviously, that caused Mr. Diamond to again get upset, and there was more of a confrontation. It was a physical confrontation, and that ultimately led to my client shooting Mr. Diamond 5 times. My client was charged with second-degree murder. Ultimately, my client entered a plea to that charge of second-degree murder, and the terms of the plea agreement were this. The judge at the sentencing hearing would be able to sentence my client within a range. The range was 25 years, which was the minimum mandatory sentence under the 1020 life law, or the maximum sentence of life. But the judge would hear evidence from both parties. The state would argue for life, my client would argue for 25, and the judge would make a determination. Fast forward to sentencing. At the sentencing hearing, the state put on some victim impact evidence. My client testified. He said that he was intoxicated on the day of the incident, said that he didn't have intent to kill Mr. Diamond. The parties made their arguments, and ultimately the trial court sentenced my client to life imprisonment, the maximum sentence. But prior to sentencing my client to life, the trial court made several comments. And the one that's the focus of the first claim in the briefs is this particular comment. And the judge says this is page 95 of the record. Let's just back up and look at the picture. I heard those calls that you made. You told them you were going to come over there and shoot them. You said it repeatedly. The state chose not to charge first-degree murder. And I don't know clearly all the evidence, but what I heard, and I'm sure there was a discussion about whether they should do that, then after that language you used and the threats you made, you followed up on that.
So, counsel, isn't that an alleged error in the sentencing process as opposed to a sentencing error?
As far as whether it could be preserved with a 3.0B motion?
Right.
Yes. I will say this. This court recently issued an Emerson decision that said that failing to conduct a competency hearing was something that had to be preserved in the 3.0B process. That's currently on rehearing in front of the court. But I will say it's not always clear as an appellate's attorney what can and cannot be preserved. The safe approach is clearly to file the 3.800B motion, and that way it can't be argued that defense counsel didn't try to, or appellate counsel didn't try to preserve it. But I will acknowledge that under the Jackson case, that yes, this would generally be an error in the sentencing process that would generally could not be preserved with 3.0B, would either require contemporaneous objection or must be considered on appeal as fundamental error. But of course I've relied upon the Bourbon case, and in Bourbon the 5th DCA found that a similar type error, and I submit it's almost identical. In Bourbon the defendant went to trial and was found guilty of possessing child pornography, and at sentencing the judge surmised that perhaps the defendant was guilty of a greater offense of actually distributing child pornography, and the 5th DCA found that that was fundamental error. That's an improper consideration, And even though it hadn't been preserved, even though in that case it hadn't even been argued in the briefs, the 5th DCA ultimately granted relief. So obviously I'm relying upon Bourbon for the argument that in this situation, considering a greater charge than what my client actually entered a plea to is improper. And here's the reason why.
Well, counsel, before you jump to the merits, I have one more question about preservation or procedure. So as you know, Rule 9.140 limits the claims that can be brought on appeal after a plea. One of the claims that can be brought is sentencing errors if preserved. So if we disagree that it was preserved, or we believe that it was an error in the sentencing process, there was no objection, it wasn't preserved, doesn't 9.140 limit your ability to raise this issue on direct appeal?
Not if it's fundamental error. I mean, again, at least no case has held that yet. The Florida Supreme Court acknowledged that there's still a category of sentencing errors that amount to fundamental error. And
Did the Dortch case from the Supreme Court change the dynamic at all, where they held that in the competency context, without moving to withdraw the plea, then there's basically no fundamental error exception to Rule 9.140?
I think the issue there is that you are in fact challenging the underlying conviction or an error in the way that the conviction was reached. And of course, once there's been a plea, anything that relates to the underlying conviction can only be presented on appeal if there's been some type of motion to withdraw the plea. This doesn't in any way concern Mr. Clakeley's challenge to the plea that he entered. He agrees that he properly entered a second-degree murder plea. He's complaining now that the judge at sentencing didn't actually consider just a second-degree murder charge, but instead considered a first-degree murder charge. So in that situation, I think it's distinguishable from Dortch. I think that the appellate courts, and again, the Florida Supreme Court, has acknowledged that when deciding Jackson and deciding what can be raised in 3.0B and what cannot, nevertheless upheld the idea that there are certain errors that are so fundamental at sentencing that can still be raised for the first time on appeal, even though they hadn't been previously preserved either through a contemporaneous objection or couldn't be preserved through 3.0B. So I think the fundamental issue here is my client went to this sentencing hearing believing that the judge was going to have an open mind. That's why he entered the plea. He gave up his constitutional right to a jury trial. But yet at the sentencing hearing, this wasn't some suggestion from some witness. It wasn't even an argument that the prosecutor made. This was the judge on his own bringing up the idea of first-degree murder. Why? What would obviously cause a reasonable person in my client's shoes to think is, well, wait a minute. First-degree murder carries a mandatory sentence of life. And if this judge believes that I'm actually guilty of first-degree murder, I have no chance in him actually considering whether I should get the potential bottom of the range, the 25 years, because in his mind, he thinks I'm guilty of more than what I've even been charged with and what I ultimately pled to. And of course, there's a fundamental difference between first-degree murder and second-degree murder. It's the mens rea. The mens rea for second-degree murder is a depraved mind, reckless indifference for human life, but the mens rea for first-degree murder is premeditated intent to kill. So this judge, I submit, it's improper, and again, it's from a fairness standpoint. Stepping back, how could anyone in Mr. Clakeley's shoes believe that this judge was really properly considering whether he should get something less than life when the judge is bringing up this idea that, wait a minute, you could have been charged with murder, first-degree murder. I don't know why they didn't. And then he goes on and makes the other comments and ultimately gives my client a life sentence. So,
Counsel, weren't all these comments in the context of right before he made the comments you point out, defense counsel had made an argument really essentially for leniency, that it just kind of happened, he went over there, the scuffle happened, he was trying to get away, and really it was in the context of, you know, a plea for leniency, give him the lower end, give him 25, and it was just the judge commenting, well, based on the evidence I've heard, and I acknowledge I haven't heard everything, you know, he made the phone calls saying, I'm gonna, you know, your dad's the first one, I'm gonna blow his head off. He went over there with a gun, you know, there's a video of it. So wasn't it just kind of a response to that, you know, based on the evidence I've seen, you know, this is my justification for not being lenient?
the intent comments, and I conceded that in my reply brief, are, and I think there may be a line there, but before I address that more thoroughly, I will point out, though, that if my client had the intent to go over there and immediately blow off Mr. Diamond's head with a gun, he would have done that immediately upon arriving. That didn't happen. He actually put the car in reverse, and there's no evidence that would demonstrate it was anything other than to try to get away. So,
But
putting
Mr.
that aside.
Diamond didn't come out until, I guess, the wife, he wasn't there immediately, was he?
No,
Stayed
Mr.
back.
Diamond came out later. No,
Yes,
certainly.
so-
But they got into an argument, and my client didn't immediately pull out the gun when he saw Mr. Diamond and shoot him. But again, I don't necessarily want to get into the underlying facts. The court certainly had a right to consider the ultimate facts, and yes, my client specifically said I didn't intend to kill him. So now, is that a consistent statement with what he entered a plea to, second-degree murder as opposed to first-degree murder? I submit certainly it can be, but I acknowledge that the judge has a right to respond to some of that and say, look, I think your actions do show, well, I'm not the judge. If I was the judge in that situation, I would say, I think your actions clearly show second-degree murder. They clearly show depraved mind, reckless indifference for human life, the way that you left those messages and the way that you went over to that house and the way that you ultimately shot him 5 times. That would clearly be permissible. But why even bring up first-degree murder? What's the possible I mean, there's no other way to look at this other than to think that this judge in the back of his mind thinks that my client should have been charged with and is actually guilty of first-degree murder. And that's the real due process issue here, right? I submit it's more in line with acquitted conduct. So I recognize the state has cited to a number of cases that it is appropriate at sentencing for a court to consider uncharged conduct. But the cases the state cites involved uncharged conduct in an unrelated matter. Now, I may disagree with those holdings, but nevertheless, Florida law has said that. They said a judge at sentencing can consider uncharged, unrelated conduct if A, it's substantiated, and B, the defendant has an opportunity to respond. And of course, a judge at sentencing can consider previous convictions. Those are actually scored on the score sheet. I think this is a different category. I think it's the same category as Bourbon. A judge shouldn't be able to consider that I actually think what you've entered a plea to or what you went to trial for, I think that your actions involve a greater crime. Because again, my client wasn't charged with first-degree murder. I don't know why the state didn't go get a grand jury indictment, but nevertheless, the judge has to deal with the charge in front of him. The judge can't all of a sudden assume that you're actually guilty of a greater offense. My client, again, gave up his constitutional right to go to trial on this charge, and yet now the judge, despite due process notice concerns and whatever jury rights you would have, is now putting in the idea that, oh, maybe you're actually guilty of a greater offense. So I almost think it's...
But is that the distinction here? I mean, clearly the trial judge didn't say, I do think you were guilty of first-degree murder. The trial judge says, and I don't clearly know all the evidence, but what I heard, I'm sure there was a discussion about whether they should do that. I mean, he seemed a little ambivalent about whether first-degree murder was appropriate, and then goes on to talk about what the evidence did show in terms of sentencing.
So if he would have said this, if he would have said, I actually think you are guilty of first-degree murder, and the sentence for first-degree murder is mandatory life, I'm giving you life. I would, obviously my argument would be stronger, and I would submit that I would hope this court would agree that that's improper. But in this, why did he even bring up first-degree murder at all? It's not relevant. It's not what he was even, this isn't even a situation where he was initially charged with first-degree murder and he entered a plea to a lesser offense. He was only charged with second-degree murder. So there's no other reason, I submit, and the burden would shift to the state if the court believes that there's a prima facie showing that this could have been an improper consideration. I submit, what other possible purpose could there be other than, again, a reasonable person in my client's shoes hearing a judge start talking about first-degree murder is thinking, wow, that judge thinks I committed first-degree murder. So it's also different situations, and the state cites some, the Johnson case from this court, where someone brings up at sentencing, I just had one recently where the officer said, I think he's actually guilty of trafficking, but my client was only charged with and convicted of possessing with intent to sell. So that happens, but then the judge at sentencing said, well, let me just be clear. Despite what the officer said, I know that he's only been convicted of possession with intent to sell. He's not been convicted of trafficking, and I'm certainly not going to sentence him to trafficking. So you have those situations, but then you have records where judges say on the face of the record during the sentencing hearing, I'm not considering that, I'm not going to sentence you for that. In this case, this isn't that at all. No one else brought up first-degree murder. The judge did it on his own. So again, I come back to the last point I'll make on this, and I know I only have like a minute left for rebuttal if I want to discuss the other claim, but I think it's akin to acquitted conduct. I cited to the Epirec case, or it's cited in the briefs, that a judge can't consider acquitted conduct. You can't go to trial, for instance, for vehicular homicide and racing, have the jury acquit you of the racing, but then have the judge say in sentencing, I'm going to give you the max sentence for the vehicular homicide because I actually think you were racing. This court and other courts around the state have all said that's improper. I think this is no different. The judge has to consider the crime for which you've been convicted and can't consider a greater offense. That violates your rights. Quickly, regarding the second issue, the statute is clear. 921 point, and I realize I'm going to go into my rebuttal time. Let me take about 40 seconds to address this very quickly. 921, 143, the legislature said that, yes, a victim has a right to be heard. This predates Marcy's Law. But if a judge is going to accept a victim impact statement, it must be sworn, whether in writing or orally. This court in Baugh found that the error was not fundamental. But the key point about Baugh is that the court said that the reason the court found that it was not fundamental is because the judge gave a sentence of 20 years, which was less than the maximum of 30 years, and the court gave no indication that the victim impact statements, the trial court, influenced the ultimate decision. Of course, we don't have that here. I've cited in my reply brief the specific statements that the judge made when imposing the sentence that he did rely upon the victim impact statements, and of course the judge did give the maximum sentence in this case. So I know the state has argued that Marcy's Law trumps the statute. My response to that would be is, Marcy's Law does not provide procedures to implement or enforce victims' rights. Marcy's Law does not provide the guidelines as to how its purpose is to be achieved. The authority to craft those rules and procedures has been left to the legislature. Of course, this statute was in place prior to Marcy's Law. The legislature has adopted statutes since Marcy's Law, implementing Marcy's Law, and they haven't changed the statute. This statute in no way impedes a victim's right to be heard. It actually allows for the victim's right to be heard. It simply says that when the victim is heard, that statement must be sworn. So I submit that, unlike Baugh, the error in this case was in fact fundamental. It did prejudice my client, and for all those reasons, I'd ask this court to reverse for a new sentencing hearing. I'll reserve the remainder of my time for rebuttal. Thank you.
And thank you, counsel.
Good morning, and may it please the court. My name is Ben Hoffman. I represent the state. I want to start with issue 1. I want to spend a considerable amount of time on issue 2 as well, but starting with issue 1, and I'll start with the context that Judge Norby was asking about. So, as we all know, judges don't just say things in a vacuum. So in this case, the judge was actually responding directly to Mr. Clakeley's testimony from just moments before. And the judge was not just responding to that, he was responding to specific assertions that Mr. Clakeley made during his testimony. So on no less than 3 different occasions, Mr. Clakeley specifically made an issue of his intent at the time he went to the Diamond residence.
Specifically, what did the appellate say to make it an issue as to his intent?
So starting with the very first question that Mr. Clakeley was asked, he was asked, and this is on page 84 of the record, defense counsel asked, was Mr. Diamond a target of this incident? And Mr. Clakeley said no. So right off the bat, he's just opened the door to it. And he didn't even stop there. So just on the next page, he then was asked, were you thinking about what was going to happen when you went over there? And he said yes. And then the defense attorney asked him, what were you expecting to happen? Or what were your intentions when you went over there? And Mr. Clakeley responded, I just wanted to talk. And I'm quoting now, I really didn't expect things to get out of hand. So that's the second way he's just opened the door. And then third, this is now on page 88 of the record, defense counsel asked him why he reached for the firearm, or what was his intention when he reached for the firearm. And Mr. Clakeley said, and I'm quoting again from page 88, I reached for the firearm just to scare him, but wound up hitting him. Now, viewed in that context, that the judge was responding directly to those 3 assertions, if not even more, that's just the 3 that I highlighted, what the judge was actually saying, which is his prerogative, was, I don't believe you when you say you didn't go over there to target him. I don't believe you when you said you grabbed the gun just to scare him and wound up hitting him 5 times, shooting him all the way down his body from head to toe.
But why make the comment, the state chose not to charge first-degree murder? Why bring that up?
So I guess the best explanation I have is, in the heat of the moment, it's an equivocal comment, much like the comment made in Serrano, which I do plan to address. But I think again, viewed in the context that this is a response to Mr. Clakeley's testimony. I mean, if I were to translate what Mr. Clakeley said from layman's terms into legalese, what he actually said was, show leniency first and foremost because I didn't premeditate. Obviously, he didn't use the word premeditate, I'm translating, but that was effectively his very first plea for leniency. The very first question he's asked, his answer was effectively, I did not premeditate. So in that context, I don't think it's unreasonable for the judge to say, well, wait a second, it's my prerogative to reject your testimony. I am rejecting your testimony. You're telling me you did not target him, i.e. you did not premeditate. That is wholly inconsistent with all the evidence that's been presented today.
Counsel, let me take you back to a more threshold issue. It's at the state's position that there is a fundamental error exception to the limitation in 9.140 over the claims that can be brought by an appellant after a NOLO plea.
I think if I understand the question, I think this is a jurisdictional question, if I understand it.
Well, and I'll be more clear. So as you know, 9.140 limits the claims that a defendant can bring on appeal after a plea. One of those is sentencing errors if preserved. The errors in the sentencing process here were not preserved. There was no contemporaneous objection. So is there a fundamental error exception to that limitation? Should we be considering this case?
Okay, I understand what you're asking. And yes, just briefly before I get to that, I think the best way to understand Jackson is, again, in simple terms, if you can object, you have to object. If you did not have the opportunity to object, then you can raise it in a motion to correct sentencing error. So for instance, issue 3, which I know we're not going to get into today, is the kind of error that you wouldn't expect someone to object to contemporaneously because it wouldn't appear until you actually get a written copy of the judgment. This is one where obviously when you hear a judge say something that you think you shouldn't be saying, you have the opportunity to object and you should. Same with issue 2 with victim impact statements. I guess directly to your question about whether there is a fundamental error exception, I guess I'll put it this way. I'm not aware of any case that has directly said that. I'm aware that Mr. Ufferman has cited Bourbon. I'm aware of a long line of case law from this court, as well as the other district courts, effectively, I don't want to say finding a fundamental error exception, effectively addressing fundamental error without that threshold inquiry.
And so in the Dortch decision relatively recently from the Florida Supreme Court, I mean, it held there's not a fundamental error exception to the limitations in 9.140 with respect to the competency issue. Do you see any analogy from that case to this case, or as Mr. Ufferman said, no, that really has to do with something that happens within the judgment itself as opposed to the sentence?
Well, I mean, to the extent that Mr. Ufferman's saying it has to do with the judgment in terms of it's not something you would see until the judgment, I do disagree. That's obviously something he would have been able to object to contemporaneously. The case is escaping me now, but there is a case from this district. I'll find it and supplement if I have to, but there is a case in another context that basically says, well, just because the other districts have addressed this question without addressing jurisdiction doesn't mean we're going to follow them. So I do agree, if that is a concern of the court, that, wait a second, we have this long line of decisions that have looked at this for fundamental error without actually taking a step back to say, do we have the ability to even hear this kind of claim? It is the state's position that you should actually address that claim, or that issue first, the threshold issue first.
Thank you.
But as to the context, again, the judge is not saying this in a vacuum. I can't answer why specifically he chose to say the words, the state chose not to charge with first-degree murder, other than it is in the context of a rejection of everything Mr. Clakeley had just said, as being inconsistent with the evidence.
But counsel, is there record evidence to support consideration of appellant's intent by the trial court?
I want to make sure I understand. Are you asking if there's record evidence that, I guess, he opened the door to it, or are you asking if there was record evidence that he actually intended it?
That he actually intended it. You addressed opening the door argument. Now, is there record evidence to support consideration of intent?
Yes. So,
And what is that evidence?
So I won't actually quote from the phone call, but to summarize, so in the phone call, Mr. Clakeley is upset, and he's saying some not so nice words about what he perceives to be the new boyfriend. And towards the end of it, he says, somewhat quoting and somewhat paraphrasing, "Meet me at your daddy's house so I can blow his effing head off." And then he spends the next 15 to 20 minutes driving there by his own testimony. He also said that he was thinking about as he was driving during that 15 to 20 minutes, he was actually thinking about what was going to happen, though he had different language for what he intended. But he says he's going to kill, here, I'll put it this way. He says he's going to kill Gary Diamond. He drives to Gary Diamond's residence for the next 15 to 20 minutes. He shows up, and within, I don't recall how many seconds or minutes it is, but within a very short period of time of Gary Diamond actually walking out of his house to see what's going on, he then ends up shooting Gary Diamond 5 times. And this is part of what the judge was actually addressing was, again, Mr. Clakeley's testimony was he grabbed the gun just to scare him and did not actually intend to kill him. And the judge explicitly rejected that and said, you say you grabbed the gun to scare him, and yet you didn't brandish it and threaten him and say, get back. You, as soon as you grabbed it, you immediately started pulling that trigger, and you didn't miss a single time. He shot 5 times, and he hit Gary Diamond 5 times. That is certainly circumstantial evidence of his intent. So to the extent that an equivocal comment on the state's charging decision is error, which we're not conceding because Mr. Clakeley opened the door, but to the extent that an equivocal comment is error, not only did he open the door, but this was, as found in Serrano, which I think Judge Ray, you wrote that opinion. In Serrano, that is the most factually on point decision. So just very briefly, Serrano was the judge who commented and even expressed disagreement with the prosecutor's decision to drop charges as part of a plea, even going so far as saying if you understood the effect those convictions had on the score sheet, maybe you would have made a different decision. Clearly not only commenting on it, very obviously expressing disagreements, and then immediately following it up with, I don't know what to make of that. And in Serrano, this court held that the brief comment followed by, I don't know what to make of that, was, quote, equivocation and nothing more, which was not the same thing as basing the sentence on an impermissible factor, which is the standard under this court's precedent. So it's not even just, as Mr. Ufferman keeps using the word considering or consideration. This court's precedent in both Serrano and Johnson sets what I would consider to be a higher standard. So this is taken directly from Johnson. There must be some affirmative indication that a trial court actually based the sentence on an impermissible factor before an otherwise legal sentence would be reversed. And again, in that instance, the court held that an equivocal comment was not the same thing as basing the sentence on in that case, on drop charges. Johnson actually took it a step further. So under Johnson, that was the case where the prosecutor, I think it was the prosecutor at sentencing, actually referred to uncharged crimes. And following Serrano, Johnson held that there was no affirmative indication that the trial judge actually based the sentence on that. And then Johnson actually took it a step further. I'm quoting now. Even if the circumstances suggest that the court might have considered the uncharged crimes, we agree with the state that there is no affirmative indication in the record that the court based its sentencing on any impermissible considerations. And in this case, keeping in mind that the judge's pronouncement, if you will, spans roughly 4.5 to 5 pages worth of transcript, this was made within, I think, the first couple of paragraphs. I mean, this was a very early comment in the pronouncement stage. And then you've got at least 4 more pages of the judge commenting directly on things that were either in evidence or things that Mr. Clakeley said himself during testimony. So at worst, this would be almost on all fours with Serrano and would not amount to fundamental error, assuming you get past the jurisdictional question. I do want to turn just briefly to, actually, before I turn to issue 2, I also wanted to point out that, so there's been talk about the burden and who the burden goes to. I'm well aware of the case law saying that even in the context of fundamental error, the state has the burden to show that basically the same sentence would have been imposed. This is the only context I can think of where an unpreserved error somehow it's the state's burden. In every other context, when the error is not preserved, it's the appellant's burden. Our position is it should be no different here, though I do recognize the language in the long line of cases that have basically shifted the burden to the state. Having said that, in this case, there actually, the judge did actually provide some guidance as to why he imposed the sentence that he did. So on page 98, he actually gives a fairly succinct explanation of why he's not giving the minimum sentence. So again, understanding that Mr. Quakely was seeking basically the minimum, or as close to the minimum as possible. As the trial judge is rejecting his testimony, he says, and I'm quoting now, "And to give you the minimum penalty required by law, I think does not do justice to the act that you did, particularly when you made every decision to continue." In those two sentences, or really that one sentence, there's no comment on anything that would be remotely considered an impermissible factor. So I think it's kind of a strange thing to argue on the one hand that the judge specifically articulated that I'm not giving you the minimum sentence for these specific reasons that have nothing to do with impermissible factors, and then all of a sudden we get to, I'm now going to give you the maximum sentence based on some other factors that I haven't just articulated. It seems like quite the stretch to get there. If there's no other questions about that issue, I do want to turn to issue 2 and address, I guess I'll start with, as Mr. Upperman was sitting down, I think it was the first time that I actually heard him articulate the word prejudice, though he didn't say how he's prejudiced, so I think I'm going to start there. The state's position is that even if Marcy's law has not changed the dynamic, which it's our position that it did, but assuming it didn't, that there's no prejudice here. So turning to, I do want to narrow this down to who specifically we're talking about, because even though the state admitted, I think it's 7 unsworn statements, the judge says he read them. Again, in the very beginning of the pronouncement, he says, I've read the letters, and then he does not refer to any of those letters again. The only time he refers to anyone else is, I think, maybe middle to end of his pronouncement. He then refers to Cindy Diamond one more time. So I want to actually focus this on Cindy Diamond, because I don't think Mr. Upperman is actually going to say that the judge relied on the other letters. I think at most there's an argument he relied on Cindy Diamond's testimony, and it's also not clear that she was under oath. So not clear whether she was or was not under oath. Regardless, though, obviously the point of putting a witness under oath is to impress upon them, basically, don't lie on what you're about to tell the court. If we look at what Cindy Diamond said, because she read her letter out loud in open court, defense counsel was given a chance to question her, declined to question her, and I think it's obvious why. Because if we look at the quote-unquote factual assertions that she made, there's nothing to cross-examine. So, for instance, she starts speaking on page 77 of the record. Just some of the factual, quote-unquote factual assertions I picked out, that they were married for 38 years. I don't think there's any concern that she's lying about how long they were married. That she was dependent on his income because of health conditions. I don't think there's any concern with whether she's telling the truth about that. And then she asserted that he was named Firefighter of the Year in 2020. Again, I don't know that there's any concern with whether she's being truthful about anything she said.
Counsel, let me ask you just a fundamental question about what the statute says or does not say. But where in the statute is there a prohibition against considering unsworn victim impact statements?
There is none.
There is none.
So, and this was exactly the point of Dickey, which I briefly cited in the answer brief. I
Now,
realized
Dickey certified conflict with the decision from this court, correct? But Dickey
Yes,
said basically if the court is presented with a sworn victim impact statement, the court has no choice but to consider it, but it doesn't, the statute doesn't say anything about the trial court's ability to consider unsworn statements in its discretion.
Right, so as Dickey pointed out, the statute really did not affect anything when it came to unsworn. So as Dickey said, if under the statute, if a victim presents a sworn statement, the judge has to consider it. If it is unsworn, the judge has discretion to consider it, as it did before the statute, which is what Dickey points out. And certified conflict with Patterson. I think it's worth noting that Patterson also really not on all fours, because it's the reversal of a summary denial of post-conviction relief. And interestingly, what Patterson, the effect of Patterson was really remanded to the trial judge to actually hold a hearing and presumably decide whether this was prejudicial. I am not aware of any case, and Mr. Ufferman hasn't cited any, that has independently said, again, this is assuming the statute really does require it to be sworn, but let's say it has to be sworn, let's say it's error to admit it. I'm not aware of any case that has just simply reversed it because it was error. I haven't found any case that actually addresses prejudice, because Patterson remanded it for the trial judge to do that. Dickey did not address prejudice because it found it was not error. And Bowe simply said it was not fundamental error, but did not address prejudice. But the point here is the state's never wavered in this position that the statute on its face doesn't require it. Understanding what Patterson and Bowe say, our position is this court doesn't really have to go en banc to resolve it, because Marcy's law has, whatever validity Patterson had is no longer valid in light of Marcy's law. So what I want to focus on in terms of Marcy's law is the stated purpose. So I agree that the legislature is free to regulate constitutional rights within reason. Obviously it can't, I forgot the verbiage, but unduly limit it. So it's Article 1, Section 16b, there's a paragraph about the different purposes that Marcy's law serves, and one of them is to, and I'm quoting now, ensure that victims' rights and interests are respected and protected by law in a manner no less vigorous than protections afforded to criminal defendants and juvenile delinquents. And it's well established in Florida that defendants have the right to admit unsworn or to make an unsworn statement at sentencing. Under Marcy's law, if a defendant has that right, then the victim now also has that right under the stated purpose, kind of like a what's good for the goose is good for the gander under Marcy's law. So our position is that no error even occurred in the first place. If it did, it certainly does not rise to the level of fundamental error. And I see that my time has expired. I'll just ask that you affirm.
Thank you, Mr. Hoffman.
May it please the court. I'm going to focus my rebuttal time just on the first issue, and I'm going to try to make it simple. Judges are clearly the heroes of our criminal system. We rely upon judges to do some things that would normally seem impossible. A judge presides over a suppression hearing, hears all the evidence, ultimately concludes that the evidence should be suppressed, and that same judge then presides over the rest of the trial, perhaps, and the sentencing hearing. And we assume, because we in our country and certainly in this state, the people that are in the position of wearing the robe are the best, and that we know that they do this. They've agreed to be impartial and neutral. We assume that all the evidence they heard at that suppression hearing, they're not going to consider. They're only going to consider what's appropriate at the time of the sentencing hearing, and that's hard to do. You think, oh my goodness, you heard that the defendant made a confession, but maybe it violated Miranda rights. But you're going to suppress that, and you're going to assume that the judge follows the law and doesn't consider anything inappropriate. Well, that's what my client assumed when he went to his sentencing hearing. He gave up his constitutional right to a jury trial. He agreed that he committed second-degree murder by entering the plea, and he also, the agreement was with the court, that the court at sentencing will properly have an open mind about whether he should get 25 years or life, and will only consider what he entered the plea to, not something that he didn't enter the plea to. Not something that he wasn't even charged with under due process notice, not something that a jury found him guilty of under the Sixth Amendment. just what he entered that plea to, second-degree murder. And I just come back to this. Why would the judge, I gave the example earlier. What if he would have said, I think you're guilty of first-degree murder? I would hope this court would agree with it. But he came close. This is what he said. The state chose not to charge first-degree murder. And I don't know clearly all the evidence, but what I heard, and then he stops himself. And then there's a dash in the transcript. I'm sure there was a discussion about whether they should do that. He is clearly insinuating what he didn't say out loud, but what the reasonable assumption from that is, what I heard is you're guilty of first-degree murder. And no reasonable person, certainly not my client, not anyone in his shoes, would believe that this judge properly considered the only charge for which he entered the plea. And if that's the case, then my client should get a new sentencing hearing in front of a different judge who properly considers, A, what he's been charged with, and has an open mind in considering whether he should get 25 years or life. I'd ask this court to reverse. Thank you.
And thank you, counsel, again, for your respective oral arguments. We will remain on the bench for a Q&A session with the students. If counsel have time available, they stay with us. And Mr. Corrin was here. I think Mr. George, if they're still here as well, ask them to join us at counsel's table for the Q&A session.